I'm grateful to Labuan IBFC to invite me this morning to share with you on the concept of trust, the common law trust, and also how the trust has been developed further and enhanced by legislative framework. So unlike Zach, who has put the fear of authority in all of us, and also, what he's speaking is really about, authority-driven. This morning, for me, I'm more looking at the aspects of what the high net worth families need in terms of family-driven objectives. So I believe most of us in the room this morning work alongside high net worth families in terms of either their wealth management or estate planning. So it might be a good spot, I thought, for us to kind of backstep a bit to examine again between ourselves what are the needs and objectives of high net worth families, so that in that way it kind of lead on to see whether the concept of trust indeed is useful in response to that need. So in my first slide, I will go on a very basic walk around on what would be the characteristics of high net worth families. So I would say, whether it is in Indonesia, in Philippines or Malaysia or any part of Asia, they share similar characteristics. First of all, the most important is, of course, we talk about significant capital base. This is the key area, really, that brings family to the space of thinking of estate planning. I would say in Asia, family wealth probably is accumulated across generations. So when we say family, high net worth family now has significant wealth, I usually would like to qualify it to say the wealth has become visibly significant in this generation. Not that it's only made it in this generation, but it becomes visible. I mean, prior years, previous generation, when the wealth increasingly became more, families still are so engaged in expanding their businesses and their wealth, they hardly pay notice to the value. And nobody pauses, every 1 year to look at how much they're worth. But with globalization, with corporate exercises like joint venture, listing exercises, the value of the wealth is flushed out now. And therefore, families now, and we are basically in Asia, we are dealing a lot with baby boomers generation. Parents are born between 1946 to 1965. They are still a generation that hold on to conservative value. They are a generation who believe wealth can have this toxic effect on children. They are a generation who believe too much wealth can lead on to consequences that are not necessarily healthy. So they, now when they see the kind of wealth that may be passed on to their next generation, they kind of step back and wonder, is this right? Should I pass everything on, or should I perhaps keep aside some to pass it on in a stewardship way? So the significant wealth, of course, is the first key driver that brings them to the space of saying estate planning. Previous generations are quite happy to just transfer their wealth directly to the children. But now the generations are looking and say, perhaps we should rethink. So the other, of course, with significant capital base, the next thing will be annual net increase. We know that chances are the income will not be used in the year itself. So the capital base becomes more significant every year. We talk about capital in diverse geographical locations. I mean, we used to just, in financial planning, we used to just talk about asset diversification. But now families talk about country diversification, basically putting it in different countries and hopefully spreading that risk. Then we have, this is an obvious factor in most Asian families, growth in family memberships across generation. I mean, I think families in a way are getting a bit smaller in size, but nonetheless, families still grow in terms of base. We call this the pyramid system, parents having two children, then have 6 children, so the family membership grows. The only type of families that we act for, which may have slightly different, is families from China, because they have the one-child policy. So you have families that have just 1 child, and if that 2 single child marry, they have 1 child. We call that the inverted pyramid system. So when we plan for families in China, different kind of considerations come in. But in most Asian families, we are looking at growth in family memberships across generation. And then finally, we have geographic dispersion of family members. This is another key driver. In fact, I would say it is one of the main reasons that we act for families in Asia to consider global estate planning. So families in Asia have the trend to want to send their children overseas to study. I think that applies to Indonesia, Singapore, Malaysia. And then, of course, when the children are overseas, you can't tell them, don't fall in love, don't settle down. They may. So when they do, and the kind of countries that we are prone to sending our children, like US, UK, Australia, these countries practice worldwide taxation. So take a very simple example. Let's say a Malaysian family send the daughter Helen to go to Canada, and she studies and she settled down there. So if the Malaysian parents transfer the assets directly to Helen's name, then all income arising from the Malaysian assets will be taxable in Canada, because Canada taxes their tax residents on a worldwide basis. So even if, of course, Helen would have paid whatever taxation that is due to the Malaysian government, because the income arises in Malaysia, but Canada, equally, she has to report the income and pay taxation. Of course, with double taxation agreement, that helps the situation a bit better. But still, if the 2 countries have different tax rates, then they might still have to be a case of paying the differences. So like, for example, in Malaysia, the highest tax rate is 27. I think in Singapore, 17, is that right? Well, in Canada, it's 50%. Depending on the province, could be up to 52%. So families may want to think about this, because last time, our norm is always tell the children, you got to come back. I remember one of my clients about 30 years ago was telling me, my son in UK, if he doesn't come back, I'm going to turn the tap off. So we understand what he means. Basically, he's not going to support him anymore and force him to come back. But now, baby boomers generation, I think the parents are a little bit more adventurous in spirit themselves. They sometimes encourage children to stay behind overseas, to work for a little while. And like I say, when they do, you do not know whether they settle down. And therefore now, a lot of families, when the children settle down, that's one issue. But when it comes to succession planning, this is when they have to realize that if ownership is passed on to the children who settles down overseas, then this ownership of assets become affected by the taxation law, succession law, and perhaps the marital regime, the divorce regime, that is in the jurisdiction in which the children settle. So if the direct transfer means if Helen owns 30, 40 million worth of assets that are in Malaysia, Helen not only have to report in terms of tax, if Helen should divorce, the divorce regime in Canada, which may look upon inheritance property differently, with a different lens than what Malaysia or Singapore would look at, or what Indonesia may look at, and because of that, it may be subject to distribution. So the question now is there, this is one of the key reasons, is there a way to actually pass on the benefits of the family wealth to Helen without passing on actual ownership? This is where I would be speaking later about the use of trust. You have various vehicles that you can make use of, but today I've been asked to share a little bit about the use of trust in this area. First of all, we would say that because our family have gone global. Children have in different places, assets are global. we may find a situation where the domestic solutions may be insufficient to accommodate the global dynamics. So, for example, say a Malaysian family themselves decide to use a trust to actually facilitate this transfer of wealth. But if the amount is significant, if it runs into billions, it may be a case where the Malaysian family may feel a trust with a definite lifespan, like 100 years lifespan, may not be sufficient. So if that's the case, a Malaysian onshore family may not be able to use a Malaysian trust because it has got a limited duration. It may have to look overseas or look to Labuan because Labuan trust now is indefinite. It has been amended. So Labuan runs a different trust system than the Malaysian mainland trust system, or you may have to look to other places like Hong Kong just amended the trust law, or Jersey and Guernsey for indefinite trust. So therefore, domestic solutions may not be the best solutions that can be, and families may have to throw their vision further to see whether other jurisdictions may come up with certain vehicles that can help. You know, there is a seat up here. I just want to say it. Yeah? Okay, yeah. So, this is a fat finger mistake. Okay. Of course, there is the need to consider the laws of multiple jurisdiction when it comes to succession planning now. You have to plan for the long term. I spoke about structure with indefinite period. That may be one option they have to look at. And of course, you would want to have flexibility. That's key. And this is the other side about adopting organized approach to maintain family cohesion. I won't have time to talk about this. This is more about the family governance structure. Maybe in our panel session, I might have an opportunity to touch on this. So what are key concerns of high net worth family? I mean, this is just coming to talk about their we just spoke about their characteristics, but their profile and dynamics drive their key concerns. First, of course, is adverse claims. Claims arising from marital breakdown. So basically, we are just saying that when you're thinking of transferring assets to the next generation, the fact remains is the life of the next generation has yet to unfold. We don't know what kind of challenges they may face. We do not know the profile change that may come on as they live in the various jurisdictions. So the question is, could we actually put it into a structure that makes sure whatever challenges they may face, either the assets can be protected from what happens in the children's lifetime, or the damage control, you know, can come in to minimize the kind of damage that can be caused to the property. So this is what families may want to think about. And of course, families think about country and political risk, imposition of exchange control, expropriation and nationalization. These concerns are not peculiar to families in Indonesia or just families in Malaysia. They are basically just common worries to all families who have significant wealth. So you would like to kind of see, is there a way to, you know, ring fence the assets and protect some against this kind of adverse influences. Then you have a situation sometimes where you may want to protect the family assets from spendthrift children. I must say that in all the families I have in Asia, it's just one family that had this concern. You know, it looks like the generation after the baby boomers have a certain degree of values instilled in them, maybe still because of the family cohesiveness, but there are occasions where you may feel that you have to protect assets from spendthrift children. Sometimes you may have to protect it from children who may have drug addiction, you know, various kind of needs, you know, like beneficiary with special needs. You might have, sometimes clients would ask, you know, Millie, is there a threshold to say that we should look into structuring succession planning? Is there a threshold in terms of the money before I should consider? So of course, there is cost-benefit analysis, because whatever structuring that you do will add layers in to give you protection, right? But the layering, like the trustees, like appointment of protectors, all this layering will incur costs. So if so we look at the costs that may come in and what are the benefits. But of course, I would say to family never forget the benefit of asset protection, because that is not translated in dollar and cents. You could see, oh, maybe tax saving is a good benefit, then you have cost on the other side. But tax saving, you know, is strange. Sometimes we talk so much, the minute we start to talk about financial benefit and we look at money in dollar and cent, then everything seems to be just on that balance sheet. We stop looking at the other intangible benefit, which is using the concepts of trust and foundation to help you to give protection. Because protection, you can't see the dollar and cent immediately until something wrong happens. But, you know, that is what you have to key in. So cost-benefit analysis is one thing, but sometimes if you have children with special needs, then you don't even talk about cost-benefit analysis. If you have a child who has special needs, then even putting 100,000 into their pocket is not something they could manage. Then you might still need to think into some kind of succession planning, even though the figure may not be so huge. Then I've talked about tax minimization. Maybe at this point I could just follow through with the example on Helen that I just spoke about. Remember we say Helen went to Canada, study, settled down. So if in terms of having to pay, and if you could, instead of giving all assets into Helen's name and put it into a trust structure, in Canada, if the trust is set up outside of Canada, it's an offshore trust, like BVI that Zach have used, like Labuan. And because the structure is set outside of Canada, outside the jurisdiction of Canada, and because the contributors of the trust assets, which means the settlor, the one who put in has no connection with Canada. That means Helen's parents. They reside in Malaysia, they have no connection with Canada. In such a way, then Canada will look at all income arising from the Malaysia assets, which are now in the trust, to be trust income, not Helen's income. And at the same time, there is no necessity to report this because there is no connection. So Canada would not at all look at a trust as if it is a Canadian trust just because Helen is a beneficiary. Canada actually looks upon it as an offshore trust. The only connection that arises is when Helen receives distributions in Canada. So when Helen receives distribution, this is where a Canadian tax resident now being enriched by an overseas distribution, Helen would have to report this tax. But if the distribution is by way of capital distribution, if the distribution is from the capital account of the trust, at the moment the current law of Canada still say is tax-free. So therefore, this is a very major benefit because Helen continues to be able to enjoy the growth and distribution from the wealth without needing to own it. Because chances are, I mean, let's say there's a 20 million, chances are Helen doesn't need the 20 million in her pocket every day. It's just that she will require wealth along the way, but then she can make the request to the trust structure to say, could you distribute? And if it is capital distribution, it is tax-free. So, okay, so the next one is family business. I think this family business concern is increasingly becoming one of the major motivator, I would say, for our clients into looking into succession planning in terms of the ownership of the family business. So as the family business grows, so does the family membership. Remember, we talk about the pyramid structure. So if the shareholding in the family business keep being transferred to various generations, then inevitably you will find a situation where there will be fragmentation of ownership structure. We act for our families that have, right now, the family business has about 68 shareholders. And each one of them, of course, owns quite a small percentage. And this becomes an extremely difficult situation when it comes to having to make decisions on the shareholders level. Many of these shareholders are themselves very well endowed. They themselves are very busy people. They may have 0.5% share, 2.5% share in the family business. To get them to come on a shareholders meeting, it can be very difficult. And the other thing, of course, is that younger generations who may be very interested in the family business, they're not coming home because they know how difficult it is in order to get, or it's already difficult to work in a family business. You are not only just facing shareholder, you are facing grand uncle behind that shareholders, you are facing nephew and nieces whom you have grown up with, but just because you're managing director, they're not looking at you as if you're the managing director. So all this, you know, family business has its own challenges. But for the younger children to come in and realize also, not only there's just 8 shareholders, but 68 shareholders, it is something that will be a big deterrent. So, you know, in families that we act for, like in Penang, it's 4th generation. I am acting for families that are already 4th generation. They have avoided very smartly fragmentation of ownership by solely, when it comes, by solely having the person who's passing over control determine which child and family will inherit ownership and the others would just get cash or financial assets. So, but that can cause quite a lot of dispute because you can imagine 2 or 3 sons have been following the father to grow the business, and suddenly you say it will be the eldest boy that will have the family inherit the shares. So therefore, the question now is there another alternative? Again, we look upon a situation where having an asset protection vehicle where you transfer it to them and children just become beneficiaries. So with that, one of the aim is to avoid fragmentation of ownership. So with the various concerns that I've just spoken about, we are speaking about doing an asset protection structure. So perhaps we have looked at this diagram. Right now, this is a kind of diagram that shows there is no estate planning. You have the founder, you have the founder right now owning directly all the assets that he may have, real estate, business asset, financial assets. This black line denotes ownership. So if there is no estate planning, the natural way will be for this black line to now come to the founder family. So with that, now, it is this black line which is the vulnerable, I would say, the vulnerable point. Because with ownership comes the worry of asset protections, comes the worry of the taxation. So if everything just goes to the founder family, then all the concern we just spoke about may not be mitigated to any extent at all. So hopefully we would say, could we look at a situation whereby we remove the black line from the founder family, and then we set up what we call an asset protection entity. So now, instead of the founder passing on the black line to the founder family, we have a structure where the structure will own directly the asset, but the family will be beneficiaries to the structure. So this is what we hope to do. So, of course, when it comes, the key question then is what kind of structure could we use? And we'll take the jurisdiction of Labuan. I mean, in various jurisdictions, they will have their own offering of different tools in the kit that we can use. And there is no one single vehicle that will fit the needs of all, of all the families. So really, to say which tool usually will depend on the family needs, the family complexion, the dynamics of the family, and sometimes the preferences of the family. So, but the more popular vehicles that are considered with Asian family, of course, we have the Labuan Trust. There's a trust that we are looking at. We are looking at the foundation. This is also offered in Labuan. There may be a situation that family may find purpose trust is another that they can look at. You may also have a private trust company. Of course, various of this trust situation revolve around the common law trust, which I hope to touch on a little bit more today. You know what? I realized my title comes always last. I didn't look at that. So anyway, I will go on the concept of trust. This is really, in a way, our main topic to say to concentrate on one type of vehicle. I'm given to understand that Indonesia, being a civil law jurisdiction, you do not have a concept very close to the common law trust. The common law trust is really a doctrine that originated from England. The origin, the development of the common law trust, I would say, were entirely British in the beginning. It was brought on to various places by the 17th to 19th settlers. So as common law were introduced to different jurisdictions, either the trust was accepted in the jurisdiction as part of the common law traditions, like in Malaysia, in Singapore, because their legal system literally just took on the common law, and in the common law, you find trust. But in some other jurisdiction, because of the usefulness of trust, you actually find that it has been adopted into a pre-existing legal system. Like, for example, in Sri Lanka, the law in Sri Lanka is the Roman Dutch law. And yet, because of the usefulness of trust, Sri Lanka has actually adopted the use of common law trust within their legal system. So when we look at a trust, we are actually speaking of a relationship. So I say it here that a trust is a legal relationship between three parties. A trust is not an autonomous juridical person and is represented by trustee. So basically, it just means that when we speak of establishing a trust for a family, once the trust is established, it is not that we have a legal entity like a company which calls its own tune. It is merely that through the execution of various documents, a relationship has arisen between three essential parties, and this relationship is both recognized and enforceable by law. So maybe I could just kind of again distinguish it from a situation of the company. A company we know is incorporated through execution of documents and then through registration. But once incorporated, the company is like a natural person. It can sue and be sued on its own right, in its own name, but that's not the case with a trust. The trust is merely a relationship that's recognized, but who represents the trust is the trustee. So this is the difference between, in terms of the concept of, of incorporation and the other side of trust. So as I say, trust is a relationship between three parties. These three parties are crucial in constituting a trust. Later on, I may speak about purpose trust, but right now, as trust develop, this is the important thing. We have what you call the settlor. In the trust language, the person who so-called the founder of the trust is called the settlor. He identified certain properties, because not every, when a party establishes a family trust, it doesn't mean they will put everything in. Usually they would go through and identify what they would like to bless children with throughout generation instead of passing it on. So they will settle those property by transferring the assets, the legal title, the assets, to another party called the trustee. So when there is this transfer, it does now mean that the trustee now becomes the legal owner of the assets. Now this is where a lot of families become a bit jittery, because our baby boomers generation love the word control and love actual control. But by transferring legal title to a trustee, in that sense, it's off their own personal balance sheet. They no longer own it. It's owned by the trustee. But on the other hand, although the trustee owns the property, the trustee is not allowed to use the property for its own benefit. The trustee has what we call a fiduciary duty to manage the trust asset for the benefit of beneficiary. We call this duty the duty of loyalty. So the trustee can't take the trust property for its own end, basically, and it has to look after the trust property and manage it with the highest of fiduciary duty for the benefit of beneficiaries. And of course, the beneficiaries are usually the families, the settler himself and his families, or whoever that he identifies to be the beneficiaries. And the beneficiary have equitable beneficial entitlement to the trust assets, which is enforceable by law. now let's look at the structural depiction that I have here. This is how we look at now. Look at this here, the settlor is, yeah, okay. So we have a settlor who originally, if you remember our previous slide, he owns this assets directly. But now he transfers it into a trust. So who is having the black line now? The black line, of course, is the trustee. The trustee has legal ownership of the trust assets, but the beneficial ownership, because the trustee can't use it for itself, the trustee looks after manages the trust for the benefit of beneficiary who will receive distribution from the trust. So the beneficiaries have another black line here, and they have the beneficial ownership. So this, in fact, is the beauty of the trust law. In fact, you know, the English jurist, Frederick Maitland, I think, he says the trust is the most distinctive contribution of common law to the general prudence of law. Because look at this. Right now, the trust, what the trust has created is what we call split ownership. Split ownership is a principle that allows one asset to be shared ownership by two parties. We're not talking about joint owner. We're not talking about. We are talking about having an ownership split into a kind of legal ownership and a kind of beneficial ownership. And because of this split ownership situation, if the trustee is being sued in its own right, say the trustee has some other transaction and it ends up to be in litigation, and the other party has a judgment against the trustee and sues the trustee for satisfaction of the judgment, the trust properties are off balance sheet on the trustee. The trustee would say that although legally I own it, beneficially I don't. So the creditors of the trustee can't get onto this trust assets because the trustees are just holding it in trust. On the other hand, similarly, if a trust is appropriately set up, not all trusts, but if a trust is appropriately set up, the split ownership also means that if the beneficiaries have creditors against them and wants to go against the trust property, the beneficiaries can turn around and say, although I have beneficial entitlement which a court recognizes in this property, but until it's distributed to me, I don't have legal ownership. So therefore, the creditors of the beneficiary would also have difficulties in getting. So, but of course, the structuring of trust is very important. But this is the basic way of tapping the best out of the trust. The split ownership is, in a way, the genius of planting into a structure that allows the split ownership. I believe it, like civil law, in many civil law jurisdictions, split ownership concept is totally alien to their legal system. In a civil law country, ownership is absolute and whole. If I own something, the creditors will be able to get every single piece of asset. But under the common law trust, the split ownership becomes a tool that can assist this kind of planning. So I've talked about trust relationship created when settlor transfer assets to trustee to be managed for benefit of beneficiaries. Trust involves split in legal and beneficial ownership. The trustee is a legal owner, but has the right to deal, so it has the right to deal with assets, but has an equitable obligation to deal with it for the benefit of beneficiaries. And with split ownership, the trust assets are not available to creditors of trustee. So now, trust constitutes the most intense of fiduciary relationship. They are called to the highest of a standard. Maybe I just pause here just to add a little. Because of the ownership that's passed on to the trustee, he has a lot of control. I mean, he can really abuse this ownership rights. Yet the trust law has developed over hundreds of years of jurisprudence, which comes to many trust principles that regulate the duties of trustees. So it is a highest of fiduciary duty. The trust itself is supported by a robust body of law. And so that's why sometimes clients will say, you see, a trustee can be anybody. It can be the father could appoint the elder son, transfer it to the elder son to hold it for the three siblings. that's all right too, because there is no qualification as to who the trustee can be, except for some jurisdiction. Like if you set up a Labuan trust, you have to use a Labuan trust company. If you set it up in Jersey, you have to use their qualified fiduciary there. But, you know, in general common law trust, anybody can be a trustee. So sometimes clients will say, you know, I am just reluctant to transfer those kind of assets into a banker that come from the trust side of the banking industry that I have not really grown to know, don't know how long the person will stay, so I'm concerned. Can I just ask my elder son to do that? So legally, yes, you could do this. But I turn around to ask is, does your elder son know the duties, the onerous duties and obligation of a trustee? Does he know that he not only, he has what we call the prudent investor, where the beneficiaries can turn around to ask him, have you managed the trust asset entrusted to you in a prudent manner? So it is not as if an owner can just put his 5 apartment empty and don't rent it. Nobody can call. But when a trustee owns the 5 apartment, he has to make sure the 5 apartment is generating income in the best of way. So he couldn't just say, I'm just too tired to look for an estate agent, I'm not doing, and he forgets to insure the apartment, it gets burned down. If you are the absolute owner, nobody's going to come after you. But if you are a trustee, it is important. So therefore, having your close friend and having your son being a trustee is really doing them a great disservice if they are not aware of what trust involves. And you might just need to have somebody who's well equipped to know how to run the trust. So now, protector. This is one of the, you know, Zach, oh yes.
Indonesia doesn't recognise trusts in the same way as other countries do, and they do see that a trustee that is a resident, tax resident in Indonesia, is subject to taxation in Indonesia on those assets. So would it not make sense to have your trustee who's a non-resident of Indonesia?
Yes, I would certainly say so. When it comes to the tax aspect, when it comes to the tax aspect of situation, that's crucial. What I'm touching on really is the conceptual aspect, and then it comes to, after first, usually we would say, what is the vehicle that fits most? Do you want a foundation? Do you want a trust? After going through that procedure where the client is comfortable with a particular dynamics of the vehicle, then we choose jurisdiction. So, and when it comes to choosing jurisdiction, taxation is one of the important thing. Another, of course, is debtor-friendly provisions, because different jurisdictions have different debtor-friendly jurisdiction provisions. And depending on the client's need, some provisions are especially important to them. So I do agree that will be coming to the next step in choosing where you would put your trust. Protector is not a key player as in key player in the trust concept. I mean, without a protector, a trust can still be valid if you have the 3 parties. But protector has been, the Office of Protector has been developed to actually provide a kind of check and balance, a degree of comfort to the settlor, because usually for us, when we set a protector, and a lot of time the settlor himself may be the protector, the protector duty will be to well, the other, maybe we put it the other way around. The trustee duty will be to inform the protector of important decisions certain period before they actually implement the decision, and usually the protector will be given the power to remove or appoint trustees. So there is a kind of check and balance. Sometimes a professional trustee will say, I want only to be removed if I'm guilty of a certain breach. You know, so the trustee will say it's not fair if I'm doing the job good and all that. The protector should not have the power to remove. So this situation, of course, is a matter of negotiation, but we always would say that really the best scenario is always to have the absolute right to remove, irrespective whether there's any breach. Because when it comes to allegation of breach, it takes time to, I mean, no trustee is going to openly say, yes, I breached, therefore you can remove me. So there may be a dispute and it may take time. And we always speak with trustees to say, trustees like lawyers, we are all service providers. If you are paid up to date for whatever services you rendered, the protector should have a right to remove. Because sometimes clients may want to remove a trustee solely because their annual fee has suddenly gone so high for the next year, right? Or the other way around, maybe the very trusted person that they have been dealing with in a trust company have left to join another trust company. It's all about relationship at the end of the day. So therefore, the protector is one of the components we put in. Sometimes we put in advisory committee, whereby we put the family in so that the advisory committee can come with suggestions to the trustee to talk about the mode of distribution. Because, you know, we hear something is wrong with my slide. Look at that. So look at that. It's like it comes in different. So anyway, maybe I talk about the letter, memorandum of wishes. That is also one of the components, especially in a discretionary trust, where the settlor, after setting up the trust, quite clearly informed the trustee how it would please him if he could administer the trust and make distribution in a certain way. Of course, in a discretionary trust, the trustees are not bound by whatever wishes that are put in the memorandum. But on the other hand, if the wishes are fair and reasonable, and if it is for the best interest of the beneficiaries, the trustees are very likely to follow through, right? But in terms of putting it in the memorandum, we always tell clients that once you have done, especially like a discretionary trust, fixed trust is a different situation, but a discretionary trust has a much larger degree of asset protection than a fixed trust. We have to remind the client that you may say, like a lot of clients would sometimes say, okay, out of the income arising from the trust asset, I would like 30% to remain in the trust, another 70% tend to go towards family activities, another 10% to go towards philanthropic activities, another 50% to be distributed between my to my beneficiaries equally. But let's say at that very point of time, when it comes to distribution, the trustee finds out that maybe the beneficiary is going through an addiction problem, say. So at this point of time, if the trustee is to distribute to the beneficiary, every dollar that is in his pocket might likely go to fuel towards his addiction lifestyle. So at that point, perhaps, in a discretionary trust, the trustee can step back and say, no, I'm not doing distribution because this would not be the best interest of the beneficiary. But usually in the trust, we also talk about notional account, that the trustee can keep notional account, keep a track to say how much they have not distributed, and perhaps when the coast is clear, they can then consider making a larger distribution. So, but the memorandum of wishes is a good start-off point for the trustee, and most trustees welcome it because it gives a roadmap where they understand the underlying needs and vision of the settlor and give them a roadmap as to how to navigate looking after the family. And of course, the terms of the trust are usually contained in the trust instrument, which is kept confidential. The confidentiality has been one of the key components of a trust because in Labuan and in most countries, you don't have to register a trust. But having said that, with CRS coming along, that kind of brings it to a larger exposure. But of course, strictly speaking, if CRS runs as it should, it's really between government. Their focus is, are you paying tax in the right way? A lot of the times, the confidentiality that client desires really is sometimes beneficiaries. You know, they don't want beneficiaries to know that they are. So, you know, like in Guernsey, you have disenfranchised beneficiaries and enfranchised beneficiaries, where there is a difference between who can get what information. Because like we say, wealth as well as knowledge of wealth, forthcoming wealth, can be toxic. And sometimes you may want the younger ones not to be exposed to it until a certain. So when we do Guernsey Trust, sometimes we will say, we will qualify the disenfranchised beneficiary to be up to 23. By 23, they automatically become enfranchised beneficiary where they can get a little bit more information regarding the trust. So these are the various various things that hopefully we can use, and that answers also your question, like, you know, choosing the jurisdiction. Tax is, of course, one reason. But, you know, a lot of the times when I work with the older generations, when it comes to balance, I mean, the minute they see dollar and cent, they say, oh yeah, this will be good. Then when it comes to balancing the other consideration, they tend to actually back off a little bit of tax on the saying that, well, I've done all I can. I'm leaving them a good stick. And if they receives it as a blessing, it's already an extra. And if they have to pay tax, so be it. You know, so they look a lot more on different provisions that may help in the trust law of the jurisdiction, so to decide which jurisdiction to choose from. And of course, we know every jurisdiction has its own nuances and own attractive features just to distinguish themselves from the other jurisdictions. So we look at that. And so, yeah, in a way, I would, if we look at trust, it's really a very flexible financial and estate planning tool. Like I say, we look at it because of asset protection, because now ownership no longer lies in the name of the beneficiaries. Sorry. Yeah, so the other one is, of course, asset preservation, you know. Hopefully, the assets could be preserved within the trust, and in that sense, therefore, it's not fragmented, it's not divided among the families. We talk about succession planning issue, we talk about confidentiality, possible tax mitigation, avoidance of forced heirship, and of course, this are relevant to Muslim families that we act for. As you all would know, I'm sure Sharia law has its own provisions regarding succession planning. But on the other hand, most of the schools of Sharia law, they recognize lifetime gifts. You know, they allowed they allowed founders to actually give lifetime gifts. And also the trust concept is not alien to Sharia law because of the waqf concept. Therefore, sometimes with the baby boomers generation, again, those are really my clients, they feel that they would like usually to favor the girls a little bit more than what the Sharia law would allow. So, and sometimes they feel a lot because the girls have been working side by side as much as the sons, and they want to kind of equalize the kind of benefit that can be done. Of course, to leave everything upon death, then the Sharia, the Ferrari division comes in. But if they take effort to do something in their lifetime, give a certain gift to the trustee, which is allowed, and also then ask the trustee to look after their children, the boys and girls, maybe in an equal fashion, or maybe sometimes they set it up just for the girls. It is something that a trust allows. But of course, then you again have to look at the so-called debtor-friendly provision of the particular country. Most offshore jurisdictions, trust law actually expressly states that if you set up a trust there, they would not entertain claims arising out of succession. So, but again, you have to carefully look through. Not likely that you will find many claims based on this, but hopefully there may be an indication among either the common thoughts between the practitioners to see how this will be, like, let's say if you set it up in Labuan, Labuan itself has a very clear provisions that says they will not entertain any foreign court claim in respect of so-called succession, succession law in that country. But it has to be looked through very carefully if that is the main concern. But trust can be a flexible vehicle to do these few objectives. And because of that, actually, you know, trust law itself has been, I would say, adopted by, like I say, Sri Lanka. There has been some jurisdiction that do not have trust law as recent as Jersey. You know, Jersey itself, Jersey law origin lies from the customary law of the Duchy of Normandy. But in the I would say the mid-20th century, the 1950s onwards, they start to adopt many aspects of common law into their system. And in 1984, Jersey, recognizing itself as one of a key financial center, actually adopted the Trust Jersey law to adopt wholesale with a lot of improvements in that sense, the common law trust. So therefore, we can actually go to Jersey now, which originally didn't have the trust law, but since 1984, you could go to Jersey to set up a Jersey trust according to the Jersey trust law. And also, of course, we have, we have the convention on the law applicable to trust and their recognition. That convention is a convention whereby several civil law jurisdictions have actually adopted the convention, whereby they comply with certain regulations, certain requirements there in terms of how to recognize trust. So several civil law jurisdictions, but on my last check, I think Indonesia has yet to ratify that convention. But still, you can see that trust law influence now has spread to various civil law jurisdictions. And of course, because of the needs, the needs of high net worth family that we serve, really have evolved into a situation whereby it becomes more complex, it becomes more varied. So they require vehicles that really serve their different needs. And several countries have, in fact, several common law countries or countries that have trust law actually have taken upon themselves and deliberately amended the common law trust to make it more attractive, more usable, and user-friendly, I would say, and that kind of accommodate the needs of the family. So maybe we can look at, this is something that Labuan has done too. Labuan Trust Act was way back in 1996, but following the needs of the high net worth families, the Labuan has actually taken special efforts in 2010 to almost, in a way, revamp many key aspects of trust law in Labuan. So when you set up a trust in Malaysia, the trust law differs from when you set up a trust in Labuan. Because in Labuan, they have amended, very big amendment, of course, is in Labuan, you can set up a trust that can be perpetual. So under the English common law, there is what we call a rule against perpetuity. So basically, very shortly, is to say that the rule says you could not have something that is within the structure in the trust forever. And there is a perpetuity period that can come on where the trust must terminate and the asset distributed to the beneficiaries. So in various jurisdictions like Labuan, Jersey, Guernsey, they have actually amended it, understanding that the wealth of the high net worth now really have ballooned. If you talk about 40, 50 million, and you have to terminate the trust maybe in 100 years' time, Singapore Trust, I think is 100 years like that, 100 years' time, that's not so bad. I mean, in 100 years, you have a lot more beneficiaries, and by then, you like settlers would say, I'll close my eyes, how they use is up to them. But if you're looking in 2-3 billion US, you might think a trust that lasts 100 years is just too short because you don't want it to finish at that point and distribute, which is a very short lifetime to use that kind of money. So therefore, a perpetual trust may be something you really have to look at. Of course, in Labuan, you can create the trust by a will. We call it a testamentary trust or other instrument in writing. You don't need to register a trust. It's optional. Express recognition of reserved powers trust. Now, that is something also very important. Under the common law trust, the more powers a settlor reserves for himself, the more danger there is that the court will call the trust a sham. Basically, the trust is supposed to be whereby the settlor transfer ownership and in a way control to the trustee, but the trustee is under obligation to administer it for the benefit of beneficiaries. But if a settlor then reserves all sorts of power, the power to manage it, the power to tell the trustees what to do, then at the end of the day, the court may examine the trust instrument and say, hey, you know, the trustee is really just your nominee, or your trustee is just your agent, it's just your shadow. You are just trying to put a sham in front whereby when your creditor sues you, you say, oh, I don't own it. But actually, all control lies with you. So the common law says you can't do that. If you have a situation like that, we may call it a sham. So now, recognizing that clients feel that giving control totally over is quite a vulnerable, put them in quite a vulnerable situation, Labuan Trust Act actually has amended to allow settlor to reserve powers without affecting the validity of the trust. I mean, you can reserve it and it doesn't affect the validity. Nobody can say you have all this power and therefore the trust is a sham. So in that sense, it gives the settlor a big degree of comfort. But I must pause here to highlight that reservation of power is something that must be considered very carefully. Because you don't want a situation to reserve power whereby a foreign court may order you to exercise the power and bring the assets onshore. So basically is, the more we would tell families, if your main objective of setting up the trust is asset protection, even in your own name, then we would say the most ideal is no reservation of power for the settlor. Maybe one way is to reserve certain power to the protector who is not a beneficiary, not a settlor. You may do that. Or maybe you do it more in terms of more a negative power, you know, it's like you could veto or you could veto the decision of the trustee rather than having a positive power to compel the trustee to act in a certain way. So because reservation of power, I always say, is like a knife that can cut both ways. It can cut the trustee because you don't want to give so much power to them, but it can cut you because if you have so much power, if there's a judgment against you, the court can order you, and you are in that jurisdiction in the court, order you to bring the assets onshore. So we would also have to consider very carefully what you say, like tax, because sometimes the tax consequences of reservation of power may means that the foreign tax authority may start to look at the trust as being managed and controlled by the settlor or by whoever that has the big power, and therefore bring that trust onshore for taxation purposes, right? So that is something that we have to be very careful, to be mindful, and sometimes also the court will say, actually with all this reservation, you know what, the property is really still under your control, and therefore it taxes it as if it's still in the settlor's estate. So therefore, we have this good provision, but like all things good, it doesn't mean it's good for every situation. So we have to use it carefully. Then, of course, in Labuan, you have, I just spoke about provision for unenforceability of foreign claim or judgment. There is statutory provision for secrecy and proceedings in camera. You can re-domicile a foreign trust. So if you have set up a trust in BVI, you could actually re-domicile it in Labuan. You could also migrate a Labuan trust. You can set it in Labuan, but for some reasons, maybe a change of jurisdiction and all that. Yes, do I see a question? Yes, there is a question at the back.
Hi. My question, or if let's say for business owners using Labuan Trust for business accession, there might be additional documents, for instance, a family constitution or family charter. Does this document build in the trust deed, or is it a separate document?
Yeah. So I would say, Josephine, can I have it back? Yes. This case. I would say just on a general basis, it shouldn't be. Family constitution, which I do for as part of a family governance structure, usually don't have validity. It really deal with soft issues of the family. We call it the intangible assets of the family, like trying to hold on to their identity, their vision, their historical values. So in that sense, usually in the charter that I draft, we actually say has no legal validity. Sometimes clients may want to put a bit of bite into the charter by saying that if you don't, then trustee can decide not to distribute general distribution to you. But generally, I would say 95% of the constitution that I've drafted, they are not part of it. But having a constitution and having a family governance structure, I think is crucial as in complementary to the trust structure. You know, maybe I'll talk about a little bit about this more when we have the panel session. Okay. So in Labuan, the trustee must be a Labuan trust company, and of course, Labuan trust assets. If you set up a trust in Labuan, it cannot be Malaysian assets. You cannot transfer Malaysian asset, but if you get the prior approval of the Labuan Financial Services Authority, then only then you can proceed with transferring the assets into the trust. Otherwise, per se, you can't do that. Oh, maybe, okay. So what I've given is, am I way out? Okay, so what I've given is just the brief introduction of the concept of trust in general. And if we can revisit just now what we say, trust general is a relationship, legal relationship between three parties, the settlor, the trustee, and the beneficiaries. And there is the general principle of common law trust is that a trust must have identifiable beneficiaries who can enforce the trust. Remember, we say legal ownership is with the trustee, but beneficiary ownership is with the beneficiary. Therefore, beneficiaries can go to the court to take the trustee to account if there has been a breach of trust, if the trustee has been lethargic in looking after the trust assets, because the beneficiaries have beneficial interest. They have standing. They can go before the court and say, listen to me because I'm aggrieved, and do justice accordingly. Therefore, from this, the other way of stating will be a court will not recognize a trust if there are no identifiable beneficiaries who can enforce it. Because the court will say, if something is wrong with it, if the trustee have done something wrong, who will come to me to call the trustees to account? So we call this generally the beneficiary principle. So then means if we move on, think of a situation where you set up a trust, a settlor pass on the trust property to another person for a purpose, that means like for a purpose to say, I would like all the money in here to go towards eradicating poverty in a small state in India. So in this sense now, there are no identifiable beneficiaries. You can't say who is someone that will have that beneficial interest, because in this case, the trust is set up for a purpose. So the general principle is purpose trust is invalid because you don't have beneficiaries who can come. However, the common law trust has developed certain exceptions to the beneficiary principle. One of them is what we call charitable trust. Charitable trusts are those trusts where it is set up for a purpose, but it is set up for a purpose which is recognized to be charitable. Now, it's quite limited what constitutes charitable purposes. For example, relief of poverty is a charitable purpose. Promotion of education, promotion of religion is a charitable purpose. Saving of life and advancement of health. So there are very specific categories before you can say that it qualified to be a charitable purpose. Now the other requirement, there are two requirements for a charitable purpose trust to be valid. The other requirement is that you must show that this charitable purpose is for the public or a section of the public. If you set up a trust to promote education among your great-grandchildren, now that's not public, because it's just a section, it's just your own private individuals, family members. Therefore, in order to qualify to be a charitable trust, there must be a charitable purpose that's recognized by law as well as the benefit for the public. So, and then how do the law steps in the gap. Remember, a charitable trust still doesn't have anybody to enforce it because it's a purpose. What in most jurisdictions that recognize charitable trust is that they have the public trustee that will be the enforcer. It will be the public trustee because after all, charitable trust by definition is for the public interest. Therefore, the public trustee will step in the gap to enforce the trust if the trustees do not use the trust assets in furtherance of the stated charitable purpose. So that's one exception to the purpose trust. Another, and there are some small exceptions under the common law, like trust for the maintenance of specific animals, trust for the maintenance of gravestones. So these are very few minor exceptions to the purpose trust. So moving on then, different jurisdictions have realized that purpose trust actually can play a very vital and interesting role in various family contexts. Like for example, more and more people now are saying, I want to do social benefit work. You know, it might not come within charitable, it might not be education, health, poverty, but it's still good social benefit work that I like. Or a person may say, you know, I come from Europe, that town has an opera house, I want to provide financial support to the opera house. Now, this doesn't come under any of the charitable purpose, but it is a social benefit situation, and it is certainly something which is philanthropic in nature, or you call it benevolent in nature, but then how do you do it? So right now, under the common law, you can't do it. So what happened is several jurisdictions have started to make legislative changes in their trust law. Again, like Jersey have done it, I think, in 1996. You have a situation of revamping by Guernsey in 2008. Labuan has done it in 2010 to make purpose trust. That means a trust which is for a purpose that is non-charitable. Because if it's charitable, it's already allowed under the common law. But a trust for the purpose which is non-charitable to be legal, to be valid, so long as it follows the legislative requirements. So we have a situation. Let's look at the purpose trust then. Just now we saw the small slide on the how a trust look like. In a purpose trust, you still have a settlor who originally owned the trust assets. So maybe the trust asset may be 10 million US, 20 million US. They want to put it, they set up a relationship of a trust with the trustee to say, I transfer this asset to you, but now you manage it instead of for the benefit of identifiable beneficiaries, you manage it in furtherance of a stated purpose. So the purpose is here. So in a way, you see here, the difference is, here they are no longer beneficiaries' name, but it is a purpose. And the big difference in most legislative purpose trusts in the countries are that when you set up a purpose trust, one of the mandatory position is you must have an enforcer. Remember, we say one of the worry about purpose trust is no one can enforce it. So charitable purpose trust, you have the public trustee or similar officer in the country. But if you want to set up your own private purpose trust in the sense, then you would need to have an enforcer. That enforcer has the role of coming to call the trustee to account if the trustee does not manage the purpose trust according to the stated purpose. And in most acts that have legislated on purpose trust, the enforcer has several powers to receive certain documents, power to bring the trustee to court as if the enforcer is a beneficiary, and power to call the trustee to account. So this is how the purpose trust looks like. So you have the parties of an enforcer is mandatory. Just now we have the other side is a protector, but the protector is optional. Some minutes, okay. So the enforcer is mandatory. So, so maybe I can just look at this. Labuan Purpose Trust, there is a provision of enforcer, rights of enforcer, duration is the same. Actually, in Labuan, if you set up a trust or an ordinary trust for beneficiary or a trust for purpose, it's the same formalities, there's no difference. But the big difference is that purpose trust, you must have an enforcer. And Labuan Purpose Trust talks about effect of uncertainty, because you know there's a lot of times when it's a purpose, clients express a purpose. It's easy to express who are your beneficiaries because you can see them. And then you can define bloodline, you can define lineage, know whether it includes illegitimate children, whether it includes adopted children. That already is quite a difficult decision, but they are factors you can kind of identify and phrase it in a definition of beneficiary. But for a purpose trust, sometimes it's difficult to really state it in a way that trustees know exactly what you want. And so sometimes it can be uncertainty, it can be a difficulty in terms of mode of execution, where you say you want to promote culture or Chinese culture. Does this particular activities, is it promoting Chinese culture? So there may be some uncertainty. Labuan Purpose Trust says you can actually go to court. You can actually, first of all, give the trustee the power in the purpose trust to resolve uncertainty, or you can go to court and have the court to either reformat the trust or settle a kind of plan of execution before having to strike it down as a purpose trust for uncertainty. So, so use of Labuan purposes, like I say, you can immediately use it for philanthropic purposes. You can use it to hold shares in a private trust company. Now, this is something that most often now we switch now. Basically, a private trust company is a company which is set up for the sole purpose of acting as trustee for a specific trust or for a series of trusts. And this vehicle is quite popular with ultra high net worth family who have extensive assets and who have different needs, whereby they feel they want to be, in a way, in control of being who the trustee is. So they set up their own private trust company, actually engage trust officers to be there, and minutes to question and answer. Okay. So engage, and then the question is, but of course the private trust company means private. It doesn't offer public trustee services. But the question is, who owns the private trust company? You may say, oh, let the settlor or some trusted family member owns it. Then there is a question of succession issue when the person passes on. A lot of time we use charitable trust to own it, so that no particular beneficiary own the shares. But when you do that, there's a question of you have to generate enough income to make some payment to the charity. So it's not the ideal solution. To work, the efficient solution now is when you can actually use a purpose trust. The purpose of the trust is actually, one of the purposes, to hold shares in a private trust company. So you have that vehicle. Then we have hold shares in family business. Now maybe I can show, this is how it goes now. This is a structural depiction of a non-charitable purpose trust. You have a settlor, it sets up a Labuan trust, right? And the Labuan trust has a private trust company that acts as trustee. But this private trust company is owned by a non-purpose, non-charitable purpose trust. So this is how, in this depiction, you can actually see the trust, two trust structure here in this situation. Oh. And thank you.